Friends, I welcome you all at Swayam platform. I, Dr. Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University, welcome you in the today's lecture where we are going to deliver discussion on maintenance under Hindu law. In today's lecture, I will discuss with you about the law of maintenance under Sastric Hindu law in Smritis, and we also discuss the maintenance law, a special reference to Hindu Adoption and Maintenance Act, Hindu Marriage Act, and what kind of correlativity exists between the Criminal Procedure Code and Hindu Marriage Act. Friends, before starting today's lecture, I want to recall what we discussed in the last class. In the last class, we summarize our discussion on adoption law, where we discussed the effect of adoption, and we concluded that after the adoption, adopted child will lose all the relation from the biological family and acquire rights and status in an adopted family as a natural son. But after the adoption, certain kind of restrictions also imposed on adopted child. First is, after the adoption, adopted child cannot marry with the member of biological family and close relatives of the biological family whose comes under the purview of subinda and prohibited degree. And before the adoption, if he possessed certain property and certain interest created in the favor of the biological son of the family, then after the adoption, the rights of the adopted child will continue. And C's doctrine of relation back is no more, and therefore what kind of property vested in the child will continue with the child, and no one can claim the property from the child on the basis of the relationship. Friends, in the last class we also discussed different section of the Hindu Adoption and Maintenance Act in order to complete our discussion. Friends, now today I want to focus on maintenance under Hindu law. And before starting the discussion on the maintenance under Hindu law, I want to identify the learning objectives of the today's lecture. The learner will able to comprehend the maintenance under the traditional Hindu law, meaning and concept of maintenance, maintenance under the Adoption and Maintenance Act 1956, and maintenance under section 24 and 25 of Hindu Marriage Act. Friends, these are the learning objective. In the light of this learning objective, we will discuss about the Hindu Marriage Act, Hindu Adoption and Maintenance Act, Sastric Hindu law in the form of Smritis. We also discuss the latest Supreme Court judgment delivered by Supreme Court in the month of May, delivered by Supreme Court in 2025. So let us start to explore the idea of maintenance. Friends, maintenance under the traditional law is not merely a legal responsibility but a sacred and moral duty arising from the concept of dharma. Friends, you can distinguish the contemporary legal system which is totally based on rights. You have a rights, or a person have a rights, then other person have a obligation. You can compel other persons to maintain you. This is the philosophy, and this philosophy is based on right-based jurisprudence. But our Sanatan tradition have a very clear idea that every liability imposed on the people in the form of duty, they have duty to discharge and provide maintenance to the near relatives. So this is the basic distinction, because after the constitution and inclusion of British colonial legal philosophy in our legal system, we focusing on rights and we are approaching everything from the perspective of rights. But prior to that, in Indian tradition, we focused and approached everything from the perspective of duty, because our system was based on duty. Therefore, we can explain the entire transition in two different categories, from duty based jurisprudence to right based jurisprudence. So friends, traditional Shastrik Hindu law imposed dharmic duty on a man to discharge duty in relation to the maintenance. Friends, maintenance under Hindu law is deeply rooted in the religious duty, that is dharma, rather than merely contractual and legal rights. Under the traditional Hindu law, these obligations arose from Dharma Shastra and authorities of these commentaries. The commentary also play the crucial role as well as Smriti to identify the responsibility of a person to be discharged in the favor of the person who dependent on the property of a joint Hindu family, or karta also responsible for that. These duties were enforced by social norm and in some cases legal system in the ancient India. The Manusmriti in chapter 3 verse 72 states that he who does not feed these five, the gods, his guests, those whom he is bound to maintain, the man's and himself leaps not through his breaths. Therefore, if a person is not providing maintenance, is spiritually and morally dead. Because if you are not spiritually and morally dead, you are bound to provide maintenance to the close relative friends. Manusmriti further state that in chapter 10 verse 10, as explained by Ganganath Jha, where he provided the meaning of dependent, aged parents, well-behaved wife and infant son have been declared by Manu to be person that should be maintained even by doing 100 evil acts. वृद्धो च माता पितरो साध्वी भार्या शिशुः श्रुतः अप्यकार्तं कृत्वा भर्त्वा मुनिर ब्रवीत. They are the dependent as per Manusmriti, and a person is liable to discharge the duty of maintenance in the context of these people's friends. Further, Manusmriti, as interpreted by the Bhullar, if a man does anything for the sake of his happiness in another world to the detriment of those who is bound to maintain, that produce evil result from him both while he lives and when he dead. Therefore, traditionally maintaining aged parents, a well-behaved wife and infant son is a sacred duty, and neglect of which leads a spiritual downfall. This is the idea of maintenance. Sometimes scholars argued that Indian had no system of jurisprudence and law. The Manusmriti and explanation of Manusmriti as given by Medhatithi, translated by Bhullar and Ganganath Jha, clearly stated that a man have a duty to maintain, and if he not discharge the duty, then a person will considered spiritually dead. This is the idea behind everything. Friends, now I want to focus on the maintenance under the Adoption and Maintenance Act 1956. Chapter 3, which includes section 18 to 30 of the Adoption and Maintenance Acts, deal with maintenance. The preamble of Act states that an act to amend and codify law relating to adoption and maintenance among Hindus. Means, therefore, we can draw a conclusion that this act amend and codify law relating to maintenance among Hindus. If the parties are Hindu, entire law now amended and codified in the form of Hindu Adoption and Maintenance Act. and chapter 3 especially focus on maintenance, chapter 2 focused on the adoption, which already discussed in previous lectures. Friends, the act recognized that it is a legal obligation to maintain wife, minor son, unmarried daughter and aged parent, as well as also the dependent. The duty to maintain these dependents is a personal in character, seems directly from the nature of the relationship between the individuals involved. Why you possess a duty? Because of the relationship. We recognize family, we recognize familial relationship, and therefore so long as the family exists, marriage exists, then duty may be discharged under this head. The act also obligation the duty of maintaining aged or infirm parents on both a son and a daughter. Friends, now I want to focus on the scheme of the chapter 3 of the maintenance under the Adoption and Maintenance Act 1956. Friends, chapter 3 of Hindu Adoption and Maintenance Act 1956 codified a legal framework governing the responsibilities of maintaining among Hindus. His duty is considered personal in nature and exist from the relationship itself. These 2 points is very crucial. Personal in nature and exist from the relationship itself, regardless the property or the financial resources of the person. The act further extend these legal obligations to female Hindus, placing upon them a responsibility to support both legitimate and illegitimate children as well as aged parents. The scheme of the act prioritizes the maintenance right to the wife from her husband, followed by the rights of minor children, both legitimate and illegitimate, from their respective parents, and then right of elderly and infirm parents from their son and daughter. This is the entire scheme of part 3 of the Hindu Adoption and Maintenance Act, which includes section 18 to 28 provisions, friends, and where the husband is liable, father-in-law is liable, parent is liable, and person who inheriting the property is also liable to discharge the duty in respect to the maintenance under this law. Friends, now in addition, the act provides the maintenance right of a widowed daughter-in-law, and widowed daughter-in-law may claim maintenance from father-in-law. After these, the act provides the rights of dependent of deceased Hindu. It is pertinent to highlight that the act align with Hindu Succession Act 1956, which grants equal inheritance right to son and daughter. As the result, both male and female are under the obligation to maintain the dependent of the deceased. Now you can infer two different kind of provision. One provision is very clear: you are liable to maintain others, and when you inherited the property from anyone, then you are also liable to maintain the dependent of deceased whose property is taken by you. This is two different notion of this act, friends. Friends, before starting the scheme, I want to focus on the concept of the maintenance under the Adoption and Maintenance Act. Friends, section 3B of the act define the term maintenance. Maintenance includes clause A, in all cases, provision of food, clothing, residence, education and medical attendance and treatment. In a case of unmarried daughter, also the reasonable expenses and incident to her marriage. the Act defined maintenance as including provisions for food, clothing, residence, education, medical attendance and treatment. In a case of an unmarried daughter, it includes reasonable expenses incidental to her marriage. In all the cases, in a case of daughter, is a distinction of the definition of the maintenance. Friends, in the case of Kiran Bala versus Bankim Chandra, the Calcutta High Court observed a very fundamental point. Justice B. Mukherjee observed that according to this definition, the provision for the 5 necessary wants is maintenance. These wants are food, clothing, residence, education, and medical attendance and treatment. This is a healthy concept of maintenance. The satisfaction of these wants is a minimum necessity of a civilized Homo sapiens, so that a man may not live the life of a dog. Friends, this observation is very crucial, friends. Friends, we are living in a democratic, progressive and developing country. So long as our courts enlarging the scope of right to life under Article 21, right to life not mean mere animal existence, the idea and scope of maintenance bound to be widened and more widened. And therefore this observation is crucial, that the law want to ensure that the person who is going to receive the maintenance should survive with dignity through maintenance. Friends, this definition of maintenance is more human than understanding of maintenance before it. Earlier provision for the satisfaction of 3 wants, food, clothing and residence, were considered sufficient maintenance. For example, Madras High Court in the year 1933 held that the maintenance include nothing more than appropriate food, clothing and lodging. In a case of Arunachal versus Anandyamal, in the year 1933, such kind of observation was made. Only food, cloth and residence comes under the purview of maintenance. But friends, now you understand the point. We developed our legal system from that point. Therefore, it also includes education and medical treatment. Therefore, it become a healthy concept of maintenance and people may live in civilized manner. Friends, the inclusion of the provision of education and medical assistance and treatment by Hindu Adoption Maintenance Act in the definition of maintenance would certainly enlarge the concept of maintenance under this law as well as under the section 125 CRPC, because initially CRPC laid down the restrictions of maximum amount, which was now abolished. Now new act is also came into the existence, Bharatiya Nagarik Suraksha Sanhita 2023. But the basic notion of the concept of maintenance enlarged, and for that the provision and definition of maintenance under Hindu Adoption and Maintenance Act play very crucial and pivotal role. Friends, in the case of BP Achalal Anand versus S. Appi Reddy 2005 3 SCC page number 313, the Supreme Court was held that right to maintenance of a wife includes right to residence. She can contest the suit of evacuation filed by the landlord if her husband made a tented house as a matrimonial home where the relations between the husband and wife are strained. The wife may be disturbed or divorced. It is possible that the husband deliberately neglected to defend the suit of evacuation by his landlord. Suppose a husband as a tenant using a room as a matrimonial home, and landlord want to evict the husband from the room due to many other reasons. Then wife have a title to to file a case and defend the case against the landlord. Why? Because right to maintenance also includes residence, and by this is the justification and the progressive approach of Supreme Court, that right to residence also includes right to defend the residence against the landlord of particular building or a particular room. Friends, the under the definition, subclass 2 talks about the maintenance for unmarried daughter. The second part of the definition of maintenance applies only in the case of an unmarried daughter, in addition to the provisions for the necessary wants. Her maintenance includes reasonable expenses of an incident to her marriage. In a case as Jayalakshmi versus T. Prakash Rao, the Supreme Court held that respondent father was duty bound. His daughters are happily married. He was directed to pay 1 lakh on the marriage of each one of the daughters. In a case of M. Aruna Kumari versus A.B. Janaradhan Rao, 2002, Supreme Court ordered the father of a marriageable daughter to pay 50,000 for her marriage. Friends, there is no responsibility in a case of unmarried son. Means if daughter is unmarried, the father of the daughter is bound to pay the expenses of marriage to her, and such kind of liability not exist in the context of son. The provision is justified due to Article 15 subclass 3, where state is empowered to enact special laws in the favor of child and women, and therefore this is constitutionally correct provisions. But fundamental question is whether it is correct socially. Friends, now the point is, unmarried daughter also includes widow daughter and divorced daughter or not? Friends, a question is whether an unmarried daughter can include a widowed daughter or a divorced daughter in its meaning. The plain reading of the expression unmarried daughter is a daughter who is never married. It does not mean daughter who has no husband. However, if we attach this meaning to the expression, the daughter whose marriage may be considered desirable. For example, remarriage of a daughter who become a widow or who had to divorce her husband on account of his fault in the prime of her youth may ordinarily considered desirable. Then the expenses of her marriage would be included in her maintenance. Marriage may safely means and includes remarriage also. So this is a very interesting point, whether expenses of marriage means expenses of remarriage or not. Suppose in a case of widowed daughter or in a case of divorced daughter, whether father is liable to pay the cost of remarriage. Friends, if we want to think only in the context of literal language, the idea is different. But if we think about the marriage and the responsibility of father in our tradition, then we are bound to compel that marriage also includes remarriage in a case of widow or in a case of divorced. and liberal provision interpretation should be favored. Friends, after the discussion of the definition of maintenance and the concept of maintenance under the Hindu Adoption and Maintenance Act, where we understand that maintenance have a wider connotation and maintenance includes the education and medical facility also, and especially Hindu Adoption and Maintenance Act focused about the daughter, and in the case of daughter the expenses of marriage also cover up under the meaning of maintenance. Before starting the discussion on the different aspects of the legal provisions, I want to focus on the law of maintenance under Hindu Marriage Act, because under section 24 and 25 Hindu Marriage Act also laid down certain rule regarding to the maintenance. Friends, section 24 and 25 of Hindu Marriage Act also provided the rule of maintenance. Section 24 of Hindu Marriage Acts deal with alimony during the pendency of suit and the expenses of proceeding. This section empowers the court to order the respondent to pay petitioner the expenses of the proceeding if it appear that either wife or the husband has no independent income for his or her support and to meet out the necessary expenses of the proceeding. Friends, the use of word support in section 24 does not mean bare subsistence. It means that the claimant spouse should be able to live more or less in comfort as the other spouse. In this regard, we have a very interesting case, and the case is V. Usha Rani versus K. L. N. Rao. Punjab Haryana High Court decided this case in the year 2001, where both the spouse had independent income, but income of husband was higher. She filed an application claiming that 10,000 rupees per month maintenance plus 15,000 towards litigation expenses. It was argued that she was entitled to be maintained in the same standard of living even if her personal earning was less than her husband or no earning at all. On the other hand, husband argued that application under this section could be granted only if the applicant was unable to maintain or incur litigation expenses. The Punjab Haryana High Court rejected the argument of the husband and finally concluded and let down the rule. The rule is section 24 could not be intended to bring about the arithmetical equality between the two. The word support should not be narrowly interpreted. It does not mean that bare existence. It means that a spouse be in so much comfort as other spouse is. Considering this factor, the court allowed 2,000 rupees per month maintenance to make her feel more comfortable and 5,000 rupees as expenses of proceeding. Friends, this is the scope of section 24 of Hindu Marriage Act, where wife can claim a maintenance amount during the pendency of suit and also the cost of the proceeding or expenses which is expensed by the wife during the pendency of suit. Now I want to focus on section 25 of Hindu Marriage Act, which deals with permanent alimony and maintenance. Maintenance that is granted permanently after the disposal of proceeding for a separation or divorce is referred as permanent maintenance or permanent alimony. According to section 25, the applicant being either the husband or wife is entitled to receive his or her maintenance from the spouse in the form of a gross sum or monthly sum for a term not exceeding the lifetime of the applicant or until the applicant remarriage. In a case of Dr. Balakrishna, Madras High Court held that wife claim for the permanent alimony was rejected as she had not made any proper application under section 25 furnishing detail of her own and other parties' income. She had got interim maintenance and played for permanent alimony by way of request which was made at the time of disposal of divorce appeal. The court observed that a Hindu wife is entitled to maintenance under two statutes, Hindu Marriage Act and Hindu Adoption and Maintenance Act. While in the former, she can seek maintenance when the proceeding under the act are filed pending, and the later act she may ask for maintenance even in the absence of any matrimonial proceeding. How we can distinguish in a case of maintenance to wife, Adoption and Maintenance Act and Hindu Marriage Act section 25. Hindu Marriage Act, there must be proceeding between the parties of marriage. Means they are in the court. But under the Adoption Act, although there is no case before the court, and thereafter by these conditions also one party may claim maintenance with others. Friends, in this regard, very interesting case recently decided by Supreme Court, Sukhdev Singh versus Sukhbir Kaur, which was decided on 12th February 2025, and Supreme Court draws significant attention due to its important role in interpretation of the application of section 24 and 25 of Hindu Marriage Act. Friends, the primary issue of this case includes whether a spouse in a void marriage is entitled to claim permanent alimony and interim maintenance. The three judges bench of Supreme Court comprising Justice Abhay S. Oak, Justice Asuddin and Justice Augustine George was constituted to examine conflicting judicial opinion on this matter. This landmark decision explained the scope of maintenance and alimony claims even in the absence of a legally valid marriage. This is very fundamental point. Why Supreme Court interpreted this? Because it's a revolutionary idea. If the marriage is void, still maintenance can be claimed, as Supreme Court held by three judges bench. Friends, in this case, argument from the counsel of appellant means husband. Husband argued that marriage once declared void does not exist under the law. As the result, the spouse should not be entitled to alimony under section 25 of Hindu Marriage Act, as there are no considered a legitimate spouse. Void marriage may involve parties who knowingly contravenes marriage law, such as bigamous marriage and involving illicit relationship. The counsel of the appellant cited a case, Babu Saheb versus Babu Saheb Magar, Bombay High Court, where he argued that an illegitimate wife cannot be equated to divorced wife under section 25, as a void marriage is not recognized in the law. Contrary to the argument of husband, wife contended that alimony under section 25 is a special provision aimed at supporting women as provided by Article 15(3) of the Indian Constitution. The council also stated that section 25 was designed to safeguard the financial interest of the woman. And friends, in order to decide the court, the Supreme Court relied number of the cases. The one case is Chand Dhawan versus Jawaharlal Dhawan, 1993 Supreme Court, where it was held that permanent alimony under section 25 can be awarded irrespective of whether the marriage is void or voided. Ramesh Chandra Ram Pratap Ji versus Rameswari Ramesh Chandra, 2005 Supreme Court, reaffirmed this position, holding that the objective of section 25 is to ensure financial sustenance regardless of whether the marriage is ultimately declared null and void. But in contrast to that, Yamuna Bhai Anantarao Adhav versus Anantarao Sivaraman in 1988 Supreme Court took a restrictive approach, ruling that a wife in a void marriage is not entitled to maintenance under section 125 of CRPC. This judgment created uncertainty regarding the rights of a spouse in void marriages. In a case of Babu Sahab, Bombay High Court held that maintenance cannot be granted in void marriage, arguing that such a relationship does not confer the spousal status. The judgment and the consequence of this case. On 12th February 2025, the decision in the present case came in response of conflicting issue in earlier Supreme Court decision regarding whether a spouse can claim maintenance after a marriage has been declared void. Even if the marriage is declared void under section 11 of Hindu Marriage Act, the spouse is still entitled to claim permanent alimony of maintenance under section 25 of Hindu Marriage Act. The court dismissed the argument that term decree in section 25 should include the decree declaring marriage void. It ruled that decree of nullity under section 11 qualifies as a decree under section 25 and allows a claim for permanent alimony. Section 25 grants family court discretionary power to award permanent alimony upon issuing any decree under the Hindu Marriage Act. The court highlighted that the allowing such relief is discretionary and depends on the particular fact and conduct of the parties involved in the matter. The court also noted that interim maintenance can be awarded under section 25 of Hindu Marriage Act even if the marriage is declared void, but as long as the condition for interim relief are met. The court acknowledged the conduct of requesting party. Friends, how we can understand this recent case of Supreme Court? The fundamental argument is divorced wife may claim maintenance under section 25 for permanent alimony. But now the case is, suppose a marriage is void under Hindu Marriage Act and it is declared by the court by a decree marriage null and void. Now the question is, marriage null and void is equal to divorce decree or not? But now Supreme Court finally concluded that void marriage and the decree of void marriage is sufficient for the purpose of section 25 and applying the section 25, and therefore Supreme Court applied section 24 and 25 in a case of void marriage and provides wife a permanent alimony by exercising the power of section 25. So this is the fundamental notion. Divorce decree provides you right as per the written rule, but court's interpretation is no, decree of void marriage is also provides you right to claim for maintenance. This is a widened scope of section 25. Friends, now I want to focus on maintenance under Bharatiya Nagarik Suraksha Sanhita 2023. It is given in section 144. Section 144 talks about the order of maintenance of wives, children and parents. This section was earlier covered under section 125 CRPC, which was well-known provisions for the purpose of maintenance, friends. Now 125 is replaced by 144, which is a secular law on the point of maintenance. Essential condition of maintenance under 144 Bharatiya Nagarik Suraksha Sanhita. If a person with sufficient means has neglected or refused to maintain his wife, children or parents, maintenance can be claimed by applying a judicial magistrate of first class. Maintenance to wife under BNSS, as per explanation in the section, wife includes woman who has been divorced by or has obtained a divorce from her husband and has not remarried, wife shall not be entitled to receiving an allowances for the maintenance or the interim maintenance and the expenses of the proceeding from her husband under this section if she is living in adultery, it without any sufficient reason. She refused to live with her husband if they are living separately by mutual consent. In both the circumstances, she cannot entitle for maintenance. In K. Bimal versus K. Biraswamy, 1991 Supreme Court held that Section 125 of the CRPC had been introduced for achieving a social purpose. The aim of this section is the welfare of the wife by providing her with the required shelter and food after the separation from the husband. Wife in section 145 BNSS means only legally married wife. The scope of section 144 BNSS cannot be enlarged by introducing any artificial definition to include a woman not lawfully married in the expression wife. In this case, Savitaven versus State of Gujarat, it was observed that the woman not legally married is not entitled to claim maintenance under section 125. But friends, this decision is now contradicted by Supreme Court, where Supreme Court concluded that women of a wired marriage also entitled to claim maintenance. Now the fundamental question is whether such kind of Supreme Court interpretation is applicable in the case of criminal law also or not. Friends, in the light we can think certain question. What does the maintenance to illegitimate children indicate about shifting societal norms? Whether a spouse is a wired marriage is entitled to claim permanent alimony and interim maintenance? What principle the court will follow for grant of maintenance where the maintenance is available under the Hindu Marriage Act, Hindu Adoption and Maintenance Act and Bharatiya Nagarik Suraksha Sanhita 2023. Friends, in the light of this, I want to conclude my today's lecture. Friends, in this lecture, we try to understand the meaning of maintenance and fundamental features of the Hindu Adoption and Maintenance Act. While discussing the Hindu Adoption and Maintenance Act, we also discussed the section 24 and 25 of Hindu Marriage Act, and we also discussed 144 of the BNSS. And friends, the progressive decision given by Supreme Court on 12th February 2025, where Supreme Court declared that a wife of wired marriage also entitled to claim maintenance under section 25 of Hindu Marriage Act. This is enlarging interpretation, but friends, we are happy to say to know that the idea of maintenance given under the Hindu Adoption and Maintenance Act is wide, and it also played a crucial role in the development of the concept of maintenance under the legal scenario of India. Friends, by this discussion, now I am concluding my today's lecture. Thank you.